So parental preference for a school. So this is looking at parents' right to request specific schools. So parental preference under the HCP allows parents to request that a specific school or institution is named in the plan. The request must be submitted within 15 days of receiving either a draft or amended draft EHCP. The local authority has a legal duty to secure the educational provision set out in the HCP, including considering and where appropriate naming a particular nursery school or post-16 setting. So this is telling you you have a right to ask for a specific school to be consulted with, not necessarily named, but to be consulted with to see whether it's suitable to be named on your child's EHCP. So what parents can ask for? Parents can state a preference for a maintained school, special school or nursery, and the local authority must consider this request unless the placement is unsuitable or negatively impacts the effective education of the pupils. The local authority is also legally required to ensure the provision set out in the HCP is delivered, including arranging and funding the agreed school placement. So this is where we'd look at the Section 38 schools and what they must consider. Rights to appeal an LA decision. One of the things to understand as well, though, you do have a right to a parental preference. The LA should consider it at all costs. However, if they do feel or deem it or decide that it would be unsuitable for the child or unsuitable for the education of others, then they do have a right. The local authority then can name a school that isn't the parental preference, which then leads on to the rights to appeal the LA decision on school. Parents have the rights to appeal if they disagree with the local authority's decision about the school named in the EHCP. The local authority must explain the evidence used to reach its decision and should involve the child or young person throughout the process. So again, when we're looking at those elusive panels about what decisions they make, and when we ask for rationales around the decisions and we get told they can't give you rationales, this basically, the law states that there should be clearly evidence-based process used in making decisions, and the LA should be able to evidence and provide this process. Mediation must also be offered as part of resolving any dispute. It is important for parents to understand both their right to choose a preferred placement and the duties placed on the local authority once that preference has been identified.